Hi, this is Dr. Dorenzo again. I'd like to welcome you to Component 7, Legal Concepts. This component of the parenting course will discuss general Florida family law principles. The presentation of this material is intended for educational purposes only and is not intended to constitute legal advice. Further, this information is not intended to answer specific legal questions. You are encouraged to discuss specific questions about your individual case with a licensed attorney of your choice. And again, I'm not a licensed attorney. I am a clinical and forensic psychologist. So I'm going to run through legal concepts with you. What I want you to focus on a great deal is about the best interest of children section. And we will run through 20 concepts that the court uses to determine what is the best interest of a child or children. So let's talk about dissolution of marriage first. And it shall be granted unless one of the following facts appears, which shall be pleaded generally. So the marriage is irretrievably broken, or there's the mental incapacity of one of the parties has been determined. So however, no dissolution shall be allowed unless the party alleged to be incapacitated shall have been adjudged incapacitated according to the provisions of Statute 744-331 for a preceding period of at least 3 years. Any injunction for protection against domestic violence arising out of the dissolution of marriage proceedings shall be issued as a separate order in compliance with Chapter 741 and shall not be included in the judgment of dissolution of marriage. In the initial pleading for a dissolution of marriage as a separate attachment to the pleading, each party is required to provide his or her Social Security number and the full names and Social Security numbers of each of the minor children of the marriage. Pursuant to the Federal Personal Responsibility and Work Opportunity Reconciliation Act of 1996, each party is required to provide his or her Social Security number. In accordance with the section, each party is also required to provide full name, date of birth, Social Security number for each minor child of the marriage. Disclosure of the Social Security numbers obtained through the requirement shall be limited to the purpose of administration of the Title IV-D program for child support enforcement. When there is a minor child of the marriage, the court may order either or both parties to consult with a marriage counselor, psychologist, psychiatrist, minister, priest, rabbi, or other person deemed qualified by the court and acceptable to the party or parties ordered to seek consultation, or continue the proceedings for a reasonable length of time not to exceed 3 months to enable the parties themselves to effect a reconciliation. And number 3, or 3, take such other action as may be in the best interest of the parties and the minor child of the marriage. Determining the best interest of the child. So Florida Statute 61.13. For the purposes of establishing or modifying parental responsibility in creating, developing, approving, or modifying a parenting plan, including a time-sharing schedule which governs each parent's relationship with his or her minor child and the relationship between each parent with regard to his or her minor child, the best interest of the child shall be the primary consideration. A determination of parental responsibility, a parenting plan, or a time-sharing schedule may not be modified without a showing of a substantial material and anticipated change in the circumstances and a determination that the modification is in the best interest of the child. Determination of the best interest of the child shall be made evaluating all the factors affecting the welfare and interests of the particular minor child and the circumstances of that family, including but not limited to factors A through T. So again, this is going to be really important if you're dealing with determining what type of parental responsibility and time-sharing schedule is in the best interest of your child. And these are the factors. A, the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. B, the anticipated division of parental responsibility after the litigation, including the extent to which parental responsibilities will be delegated to third parties. C, the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. D, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. E, the geographic viability of the parenting plan with special attention paid to the needs of school-age children and the amount of time to be spent traveling to effectuate the parenting plan. This factor does not create a presumption for or against relocation of either parent with a child. F, the moral fitness of the parents. And in a custody evaluation, psychologists do not determine morality or moral fitness of a parent. Ethically, really shouldn't. G, the mental and physical health of the parents. H, home, school, and community record of the child. I, the reasonable preference of the child, if the court deems the child to be of sufficient intelligence, understanding, and experience to express the preference. J, the demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. K, the demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. L, the demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. M, evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, regardless of whether a prior or pending action related to those issues have been brought. If the court accepts evidence of prior or pending actions regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect, the court must specifically acknowledge in writing that such evidence was considered when evaluating the best interests of the child. N, evidence that neither parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. O, the particular parenting tasks customarily performed by each parent and the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. P, the demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Q, the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. The capacity and disposition of each parent to protect the child from the ongoing litigation as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to litigation with the child, and refraining from disparaging comments about the other parent to the child. S, the developmental stages and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. And then T, any other factor that is relevant to the determination of a specific parenting plan, including the time-sharing schedule. So, one of the things that I do as a psychologist is social investigations that used to be known as custody evaluations. And these are the factors that I focus on when assisting the court in determining what is in the best interest of the child in a social investigation or a custody evaluation. All right, so let's talk about shared parental responsibility and sole parental responsibility, and we did touch on this in prior components. So it is the public policy of the state of Florida to assure that each minor child has frequent and continuing contact with both parents after the parents separate or the marriage of the parties is dissolved, and to encourage parents to share the rights and responsibilities and joys of child rearing. The court shall order that the parental responsibility for a minor child be shared by both parents unless the court finds that shared parental responsibility would be detrimental to the child. In ordering shared parental responsibility, the court may consider the expressed desires of the parents and may grant to one party the ultimate responsibility over specific aspects of the child's welfare, or may divide those responsibilities between the parties. Child support. Florida law establishes guidelines for the court to use in determining child support payments. A table of minimum amounts is provided for parents whose combined net annual income is $120,000 or less. If the parents' combined income is more, a formula is applied to calculate support. Florida has guidelines for determining the amount of child support that is provided for children. If a parent remarries, the new spouse's income is not considered for support because he or she has no legal obligation to support the children. Primary parts of a support order. Social security number of each child, the amount to be paid to each child, how frequent payments will be made, and the manner of payment. What if the percentage of annual income is not sufficient? Unfortunately, this is a common problem, as either the spouse does not make a sufficient amount of money, or sometimes the spouse is hiding income. If the latter is true, you can petition the court for support for things like education. Child support payments. Additional helpful information is provided below regarding child support payments. If one party is ordered to pay child support through the Florida State Disbursement Unit, you may find this information helpful when making payments or to keep track of payments you have made or received. This site allows you to set up a secure account, resulting in less data to remember each time a payment is made. Payments can be made by credit card. In order to make sure payments are being sent, the site allows the parties to view payment history. When logged in, a payer or recipient can view the last 5 transactions made on the case. The site is available 24/7 and provides a convenient way to keep track of a child support account. Child support payment information, check out that website, myfloridacounty.com. Leave it up there a little longer for you, myfloridacounty.com. Visitation. Definition. The time divorced parents are allowed to see their children. It is important for children to visit regularly with both parents in order to maintain strong bonds. And if you notice, this word is not custody anymore. It is a visitation, because children have a right to visit both parents. Well, nobody has custody. Parents share their children, and they visit now both their parents. A parent may not be denied visitation rights with their children just because the child believes the parent is bad, the other parent is sleeping with another partner, support payments are late, or the other parent is homosexual. However, there are justifiable situations when visitation may be legally blocked. These include extreme mental or emotional instability, violent abuse toward a child, criminal actions, illegal drug use, alcohol abuse, parental neglect, and explicit sexual behavior in the presence of the child. Mediation. Family mediation is a process to help couples involved in separation and/or divorce reach a fair and realistic agreement. The goal of mediation is to enable the couple to avoid unnecessary litigation, minimize acrimony, remain active participants, and resolve differences. Mediation is appropriate when a couple decides to divorce. Both partners attend an orientation session where mediation is explained. Then couples negotiate with a mediator and resolve such issues as living arrangements, property division of assets, and family support. The mediator collects and analyzes information about assets, liabilities, and current and future budgetary needs. Once an agreement has been reached, the mediator prepares a resolution of the issues, and the parties take the document to an attorney for legal review and formation of legal documents as needed. Guardian ad litem. A guardian ad litem is a special guardian appointed by the court in which a particular litigation is pending to represent an infant, ward, or unborn person in that particular litigation, and the status of the guardian ad litem exists only in that specific litigation in which the appointment occurs. The guardian ad litem program established by the Florida statute serves the juvenile, criminal, and family law divisions of the court. Guardian ad litem volunteers are trained to represent the interests of abused, abandoned, or neglected children who come before the court. Final judgment. This is a legal document that grants the dissolution of marriage and either references a settlement agreement entered into between the husband and wife or sets forth the details of property division, child custody, visitation rights, alimony, child support, etc. This document incorporates all the pertinent rights and obligations that the divorcing parties have to one another as well as to the children. Modification. Either party may seek a modification to the terms of the final judgment when there has been a substantial change in the circumstances of either party. These types of changes would include matters such as the loss of a job, the reduction in pay by one of the parties, substantial change in behavior of the parent toward the child, which might be pertinent to issues of custodianship or visitation rights. The court will typically not entertain a request for modification if the party seeking modification is not in full compliance with all obligations in the final judgment. If the court grants modification, the order modifying the final judgment becomes the controlling document setting the rules and rights of the parties.